Well, a case can be international for a variety of reasons. At its simplest, you could have an English couple living here, but they've got a property in Spain that they stay in quite regularly. You could have a couple where one of them comes from a country other than England, or where you're working abroad. Either you're English working in a different country, or you're not English and you're working here. So all of those we can term international cases.
In London, we have a huge number of international marriages. But I would also include other disputes, for example, abduction, child abduction disputes where children are moved from one country to another. And an international case could involve a dispute relating to foreign property or assets.
We're a very mobile world now, and I'm finding, in my own caseload, increasingly there is an international element, very common indeed. And it's not just in London, and I think it's important to stress that it's not just families with a lot of money. We can see people in quite ordinary jobs having those kind of international connections.
And why does it matter where you raise these cases?
It can matter terribly from a financial point of view. England is sometimes referred to as the divorce capital of the world, i.e. financial rewards here can sometimes be, cannot be bettered anywhere else. And that has given rise to something known as forum shopping, i.e. potential divorcing parties will often try to issue proceedings in a jurisdiction which benefits them.
And why should I come to a collaborative family law member?
In a word, expertise. I hope that doesn't sound too immodest, but we are all members of the International Academy of Matrimonial Lawyers, recognised to have expertise in the law of our own country, but also access to a worldwide network of family law experts. So if somebody comes to me and says, I'm getting divorced, I'd like a divorce, my husband's from Germany and I'm not quite sure whether or not we should be doing it here or in Germany, I could pick up the phone to somebody not only that I've found from a book, but somebody I've met and know, and get instant advice on the situation there to guide us as to how we're going to proceed.
Our task and our message is quite simple, to bring dispute resolution to complex and often international family cases.
But cross-border disputes must, by their very nature, be very difficult. So is it ever possible to actually introduce the collaborative approach successfully into these things?
It can be very difficult, and quite often there would have been proceedings, for example, steps taken by one party to secure jurisdiction. But that does not preclude the possibility of the parties involved and their lawyers sitting around a collaborative round table and exploring practical and sensible ways of resolving the issues which have arisen as a result of their divorce, their separation, their estrangement.
So what are the benefits of keeping out of the court system?
Well, first of all, you control the agenda, which is very important. You talk about what's important to you, not what somebody else thinks is important. And you reach an agreement. At the end of the day, you reach an agreement that's likely to be something you can both live with, whereas if you get a judge to impose a decision, one of you may be happy, the other one may be very unhappy, or as we find very often, neither of you ends up being happy.